Today I'm going to be talking about an issue that I am sure we are all becoming increasingly aware of, the concept of trauma-informed legal practice. This is an issue which has been gathering momentum within the profession. The Law Society of Scotland began a certified course in trauma-informed practice in December, so we now have our first cohort of certified trauma-informed solicitors from all areas of the profession: criminal, civil, private practice, local authority. The High Court recently approved a new guideline from the Scottish Sentencing Council, the Sentencing Young People Guideline, which requires courts to have regard to rehabilitation as a primary consideration when sentencing young people. The guideline highlights the need to take into account factors common to many young people who commit offences, such as experience of trauma, including traumatic bereavement and high levels of adverse childhood experiences. More on that in a moment. It also reflects the growing understanding of the way in which young brains develop and react to trauma. So in a number of ways we're very fortunate to be involved in this sea change within our justice system in relation to the way that we understand and reflect the impact of traumatic childhood events upon future offending. It's also important that we continue to improve our understanding of trauma in order that these changes have the maximum benefit for ourselves and for our clients. The purpose of this talk is to give you some more information about the impact of trauma on clients and on ourselves, and to give you some practical ideas about how to work in a trauma-informed way. Today, we will cover what we mean when we talk about adverse childhood experiences, how these traumatic experiences can impact future life, why this is important for practitioners, and what practically we can do about it. At the outset, I appreciate that many people will have had their own experiences of trauma. It's important to recognise that some of this content may be personally as well as professionally relevant to you. If any of this resonates personally to the extent that you are experiencing distress, think about taking a break and returning to the talk at a later time. So what do we mean when we talk about trauma-informed law? A really good starting point is to look at childhood experiences, and the acronym that's often used is ACEs, Adverse Childhood Experiences. The term adverse childhood experiences was developed following a study in the United States. Dr. Felitti ran an obesity clinic, and he observed that in the clinic there was a 50% dropout rate, but the people who dropped out were actually the ones who were losing weight. He also observed that many people would lose significant amounts of weight but then put it all back on, and he wanted to find out why this was happening. He began to ask people participating in the obesity clinic about things that had happened in their childhood. The purpose of this was to try to find out why they were using eating as a coping mechanism, and why they were returning to this coping mechanism even when they were beginning to do well and beginning to lose weight. And therefore, the Adverse Childhood Experiences study was born. Dr. Felitti and his co-author Anda considered a number of stressful events occurring in childhood and whether those had links to future health issues. These stressful events included domestic violence, parental abandonment through separation or divorce, having a parent with a mental health condition, being the victim of abuse, whether physical, sexual, emotional, being the victim of neglect, and again that could be physical or emotional, having a member of the household in prison, or growing up in a house in which there were adults experiencing alcohol and drug problems. And these events were characterised as adverse childhood experiences. Felitti and Anda devised a questionnaire to effectively score these ACEs in the participants and to see if there was a correlation between experiencing adversity and poor health outcomes. Now, whether an event actually is traumatic depends on a number of different factors. It depends on the type of event. it depends on the way in which the person experiences it, and then the effect it has upon the person. That's known as the 3 E's: event, experience, effect. Traumatic events are common during everyone's lifetime. Most of us will be exposed to events that have the potential to cause disruption and distress. Not all will be experienced in a way that causes ongoing trauma. A key message when considering how to work in a trauma-informed and trauma-responsive way is to think about buffers for these distressing events. We should remember that, particularly for children, one good adult relationship, just one other adult, can mitigate and ameliorate the effects of toxic childhood stress and adversity. So I would imagine that many of us in our day-to-day work deal with families and individuals experiencing one or more of these issues. We'll probably also be dealing with individuals who may have experienced one or more of these issues in the past. This is why that I suggest that understanding the science is directly relevant to the work we do as lawyers and to getting good outcomes for our clients. So going back to the study, what were the findings? We found that ACEs are common. So in the original study, 2 out of 3 participants had experienced one or more of these ACEs. 1 in 8 had experienced 4 or more. And the next one is really the bedrock of why I'm here today, why I hope we're all here listening to this. The more ACEs experienced by an individual in childhood, the greater the risk of developing a range of mental, social and physical health issues as an adult. So the participants who'd experienced 4 or more ACEs were far more likely to experience health problems or to engage in behaviour that posed a risk to health. So those with 4 or more ACEs were 2.9 times more likely to suffer from heart disease, 1.6 times more likely to have cancer, almost 4 times more likely to have lung disease, 4.6 times more likely to suffer from depression, 12.2 times more likely to attempt suicide, 2 times more likely to smoke, 7 times more likely to experience alcoholism, 9.7 times more likely to use heroin or crack cocaine. They were also more likely to have experienced or perpetrated violence and to have been in prison. So again, 4 or more ACEs, 5.2 times more likely to have been hit in the 12 months prior to the study, 7.9 times more likely to have hit someone in the 12 months prior to the study, 8.8 times more likely to have been in prison or in the cells. The study also found that on average, people with 6 or more ACEs died 20 years earlier than those with none. How does childhood stress and adversity lead to these outcomes? What's the correlation? The science tells us that exposure to persistently high levels of stress, the type of stress caused by these adverse events, causes physiological changes to the makeup of the brain, causes changes to how our bodies work, and it can lead to maladaptive self-soothing behaviours, smoking, substance abuse, overeating. Those compromise health outcomes, well-being, and can lead to exposure to the criminal justice system. When children are exposed to these adverse and really stressful experiences, it can literally affect the biological makeup of their brain. It can have long-term, lasting impacts on their ability to think, interact with others, and on their learning. I would say as an observation that there has been some discussion about whether surveying people, whether counting up the ACEs is the most helpful approach. And I don't intend to go into that in too much detail today due to time constraints, but there are important things to remember. The list that I have given here is not an exhaustive one. Any event that causes trauma can be an adverse experience leading to toxic stress. Also, there is absolutely no expectation or suggestion that you as a solicitor should be surveying your client's childhood trauma. We're not trained for that, and our role is not to act as counsellors or psychologists. But When clients feel safe, empowered, and working in a collaborative relationship, this information can often come up in an unforced way. So it's important that you have the tools and ability to deal with these types of disclosures and information if they come up. There has not been a Scottish ACEs survey. It is, however, generally accepted that we can assume there is a similar prevalence of ACEs in the Scottish population as has been found in studies carried out in England and Wales. The Welsh study is particularly interesting, and most guidance published in Scotland proceeds on the assumption that if a Scottish study were to be carried out, the results would be broadly equivalent. Turning to the Welsh study, in Wales, almost 50% of participants experienced one ACE. 14% experienced 4 or more. In the English study, almost 50% experienced one ACE and over 8% 4 or more. I would suggest to you that we can take as scientific established fact that ACEs lead to verifiable poor outcomes, not only in relation to health inequalities, but in relation to adult relationships, educational attainment, and other outcomes. A major misconception that I would like to emphasise here is that childhood adversity and adverse childhood experiences are not simply the purview of other people, or of poor people, or of people from different socio-economic backgrounds. Participants in the original American ACE study were white, middle-class, college-educated adults. However, we cannot ignore the fact that there is more risk of ACEs being experienced in areas of higher deprivation. It is very important that we do not view this as a them and us problem. This is an us problem. And you might be thinking, why is this important for solicitors? This knowledge will help all solicitors to think about ways in which they can develop their practice to minimise trauma and to take into account the way in which trauma can affect the instructions that we receive, the way that clients process information and make decisions. For example, for any lawyers who work with families and children, the work that we do in that regard can echo through generations. Criminal law practitioners are often dealing with the product of adverse childhood experiences. Family and child solicitors are often there when these experiences are actually being created. We also deal with clients day in, day out, who react to stressful events in ways that we can understand better if we take into account that they may have experienced toxic stress in childhood. We can adapt our practice to make sure that we get good instructions, workable instructions, and that clients have been empowered to make good decisions. We need to consider how to avoid our own work with clients and the experience of navigating a court system or even a negotiated process becoming yet another adverse experience of toxic stress. When looking at solicitors, it's helpful to consider some NHS Scotland guidance which defines different types of workers dealing with trauma. And a type of worker that they have noted as trauma enhanced are those who have a specific remit to respond to people known to be affected by trauma. Workers who are required to provide advocacy, support or interventions, or are required to adapt the way they work to take into account trauma and to minimise the risk of re-traumatisation are referred to as trauma enhanced. And I would suggest that most practitioners fall under the category of trauma enhanced workers in one way or another. Therefore, it is exceptionally important that we start to understand trauma. And that leads me to think about trauma responsive practice. Much is made of trauma informed practice. Being informed is really, really important. I believe that it's not just enough to be informed about trauma. Having knowledge and doing nothing about it is not why we do the job that we do. We also need to learn how to respond to it. We need to recognise that the consequences of adversity experienced in childhood aren't always immediately apparent. So we need to think about immediate risk to children, ongoing child protection, our clients' immediate reactions, but we also need to think about the impact of these experiences and their broader consequences for society. In family law, we can remember the importance of supporting adults in a parenting role who may themselves be experiencing adversity in order to improve children's experiences. In criminal law, we can remember the impact of trauma when addressing decision makers. While litigation can be unavoidable, alternatives such as mediation and collaborative practice, where appropriate, might provide a different framework for a trauma-informed resolution. On the criminal justice side of things, there may be interventions rather than imprisonment that can take into account offending but also traumatic childhood events. When negotiating in any aspect, think about language, think about modelling respectful communication and respectful relationships. When cases are in court, practitioners can be mindful of unnecessary arousal from the court environment. Think about trauma triggers. In the time that we've got left, I thought it would be helpful to run through some practical pointers that you can think about adding to your toolbox, just moving us away from knowing about trauma to thinking about how we can respond to it. And a useful concept I've learned about is the window of tolerance. So, clients are best able to cope with stressors and triggers when they can manage the emotions that come along with these triggers. A helpful concept to help us understand how we can help clients manage within a difficult legal process is the window of tolerance. The window of tolerance is a concept originally developed by Dr. Dan Siegel, and it describes the optimal zone of arousal where a person functions in their everyday life. So the optimal zone is where they are able to manage and cope with their emotions. There is a zone or window in which they can take things on board, move forward, even if things are difficult. With clients who have experienced trauma, it's very difficult for them to regulate emotions, and this zone, this small sliver where they can tolerate stress, becomes very narrow. They cannot function effectively. When a client is traumatised, it can be really difficult for them to stay grounded in the present. The past can be more vivid and intrusive. Someone constantly living in their past trauma is primed to detect threat and enter into a state of defence. You will have heard phrases like fight or flight. People like this generally have a very, very narrow window of tolerance. The stress of a traumatic memory or trigger may cause them to be pushed out of their zone of tolerance. Even seemingly minor stressors can cause a client to disassociate, get angry or feel anxious, and these states are known as hyperarousal or hypoarousal. In hyperarousal, clients may feel anxious, angry, out of control or overwhelmed. Reacting takes place over thinking. If a client is hyperaroused, they are unlikely to be able to think clearly about their future. Their brain is not primed to look at the future at that point in time. In hypoarousal, clients might appear zoned out, numb, frozen. Again, this reaction just takes place over thinking. So think about trying to get instructions from someone who's very, very angry or someone who's conversely just not engaged in the process. They might not be able to interact with you. They might not be able to give you clear instructions. Some people will simply avoid dealing with the situation at all. So these can be the clients who don't answer letters, don't answer phone calls, don't turn up for court hearings. All of this then makes it difficult, A, for you to help them and to get instructions, but for them to make progress in resolving disputes. Again, another caveat, we are not therapists. We are not expected to fix these problems, but understanding what's triggering someone, what's causing them to react in the way that they are, can then help us to adjust our practice to make it more likely to lead to good outcomes for clients, but also for us. It's really important to hold in mind that a person's behaviour or reactions at all stages of their journey through the legal system can be trauma related. It's important to understand that court, litigation, negotiation, even just telling a solicitor about the situation can invoke past trauma and create new trauma. Practitioners should be trying to work in a way that reduces the risk of trauma-related distress and helps keep people within their zone of tolerance. And the way to do that is maximising choice, collaboration, trust, empowerment, safety, and also your own self-care. So choice, practical tips. Talk to clients about how they would like you to communicate with them. Do that at the start. Some people find unexpected phone calls really difficult to manage. Some people prefer verbal rather than written communication. Some clients will find it easier to tell you the story in an email so that you don't need to ask them too many painful questions. Think about exploring these choices with them in advance. Some clients benefit from choosing the sex of their lawyer. Gender relationships can play out if this isn't considered in advance. If cases are in court, explore vulnerable witness measures to allow clients to give evidence without an ex-partner observing. Collaboration. Engage with your client to co-construct an understanding of the most appropriate way forward for them and any children involved. Consider what might be informing the behaviour of the other party, that could be another parent, in disputes. If you have a dispute involving a child, help your client think about how best to respond. Remind them that their child's relationship with the other parent is not the same as their own. Consider whether alternative forms of dispute resolution might reduce trauma and enhance self-determination. Control. Be clear about what will happen, when and why. Get in touch when you say you will. If someone else has to attend court with your client in your absence, tell them that this will happen. If you can, let them meet the other legal advisor in advance. I appreciate that not all of these ideas are possible to implement every time, but they are ideas on how to create good working practices. Empowerment. Encourage people affected by trauma to access services, supports, and interventions to improve their chances of recovery. This can include parenting interventions. Find time to listen to the client's experiences and understanding of conflict. Use this to help inform decisions and advice. Ensure clients know what they can do to enable change, find solutions, and focus on resolution. This can be more powerful than focusing on a case to undermine the other party. Trust and safety. Help regulate emotions, both your own and your clients', and this does include acknowledging distress. When a client feels emotionally contained, they are much more likely to be able to listen to legal advice and to make decisions that are informed by the best interests, rather than being driven by an emotional reaction and perhaps regretting that later, walking back from a settlement, complaining about the advice received. Let clients have the chance to become familiar with meeting spaces and courts. This can include simple things like knowing exactly where to report on arrival, where the toilets are, what will happen through the day, including potential for delays, and the layout of the court. In the world of Zoom conferencing, tell them about muting. Are they expected to be on video? Are they expected to speak? Ensure that clients are prepared for the questions that they might be asked in court. Cross-examination can be particularly distressing. Be aware that you could be cross-examining a vulnerable adult in court. Think about how to cover your points without triggering trauma. In child cases, children will not benefit from decisions informed by parental distress rather than parental capacity. And that analogy applies to any client. Decisions and evidence caused and created through distress is not the best evidence for a court to base decision making on. Be mindful that the adversarial court process can mirror relationships between parties. For example, abusive, critical, or undermining behaviour from one solicitor to another, excessive criticism from the bench, entrenches conflict, exacerbates distress, and ignores the real needs of the parties, including, again, children. Respecting the contribution of the other side is a way of modelling safe relationships. And among all of this, it's imperative that we take time for self-reflection and taking care of ourselves. Spend some time trying to understand what drives your behaviour, why some cases mean more to you than others, and when your own desires influence decisions. Try to seek support from peers, look at supervision, look for mentors. If something specific in a case has been triggered for you emotionally, try to look for help and guidance, whether this is from colleagues, friends or professionals. Look to allow reasonable goals for time management, relaxation, as well as personal and professional development. I consider that a key part of becoming a trauma responsive practice is building into the entire profession good relationships and supports, and turning what can be called vicarious trauma, i.e. trauma experienced by solicitors, into vicarious resilience. We work together to deal with our own trauma. Current research in England and Wales suggests that there are huge numbers of family solicitors considering leaving the profession due to stress and burnout, and I think a large part of that comes from the types of cases we deal with, the way we've become accustomed to dealing with them, and being trauma responsive means that we have to look at how we can change that. As part of that overall process of becoming more trauma responsive, building up vicarious resilience, I would invite anyone who would like to be more involved or who wants to start doing what they can to please get in touch with me. Think about joining Trauma Aware Lawyers, a group I'm really proud to have founded with Ian Smith, Melissa Rutherford and Tony Bowen, with non-lawyer members Kirsty Giles, James Docherty and Stephen Bennett. I've got lots of resources that I can signpost to anyone interested to. My email address will be circulated with the talk notes. I would also encourage anyone who's interested in trauma-informed practice to consider signing up for the Law Society certification course, which gives far more detail into the types of topics that I've touched on today and a practical viewpoint on how to continue your practice in a way that creates trauma-responsive practices and responses to clients. Thank you for taking the time to listen to this today, and please do get in touch with me if there is anything that this talk has raised that you would like to consider further.